For our next session, please join me in welcoming our moderator for the panel discussion, Mr. Ng Chong Yuan, Faculty IP Academy. Chong Yuan and his fellow panelists will be discussing protecting your brand and other intangibles, the legal perspective. Over to you, Chong Yuan.
Hello, everyone. Welcome once again to FLAsia 2021 virtual edition. The title of today's webinar, lasting about 40 minutes, is Protecting Your Brand and Other Intangibles, the Legal Perspective. My name is Chong Yuan from IPOS International. I teach at the Academy of IPOS International, and I'll be your host and moderator for this webinar. IPOS International was set up to assist enterprises and industries in their use of IP and intangible assets through patent and technology intelligence, IP literacy and skills training, and IP management advisory. For myself, as a Singapore qualified lawyer and lecturer, I've conducted training on IP and management of intangible assets in a variety of professional courses in university, and other events covering intangible assets. For today's webinar, if you have any questions that you wish to ask our speakers or any comments, we welcome you to type them into your platform's Q&A panel at any time, so that our speakers may get in touch with you. Some questions may not be in a format that could be readily addressed in this webinar. So please consider leaving your email address and other contact details for our speakers to get in touch. If these details are missing, we could try to identify you and use the contact details in your registration to get in touch as well. But before we start, please allow me to introduce our speakers today. They are from, I would like to call them the A team. Okay, notwithstanding, of course, they are, in my view, A speakers with a capital A. Incidentally, all their first names start with the letter A. So first with us today, we have Miss Angeline Suparto. Angeline is qualified to practice law in Singapore, Hong Kong, England, and Wales, and Australia. With over 36 years of legal experience, I'm not sure I can do her justice with any brief introduction, but let me try. Angeline has represented many clients, including multinational corporations, publicly listed companies, government-related entities, and not to forget small medium enterprises. She has also served as a council member of the Singapore Manufacturing Federation. Angeline is a founder of Angeline Suparto Law Corporation and is a senior consultant, though non-resident, of Tuah and Suparto, a law firm in Indonesia. Next, we have Mr. Andy Leck. Andy is presently the head of the intellectual property practice group in Singapore and a core member of Baker McKenzie's regional IP practice. Andy has represented some of the owners of the world's best known trademarks, brand names, and technologies. Andy's IP experience covers all aspects of commercial and advisory work, anti-piracy, even civil and criminal enforcement, portfolio management, and disputes. He also regularly advises on commercial exploitation of IP rights, particularly in the following fields: technology, franchise, which we are all interested in, pharmaceuticals, and media industries. Last but not least, we also have Mr. Andrew Tuah, who is a qualified lawyer in Indonesia and is based in Indonesia for more than 15 years. Andrew specializes in foreign direct investments into Indonesia and cross-border transactional matters. These matters include legal due diligence, acquisitions, and real estate. He's also experienced in advising overseas clients on supply chain relocation and employment relations. Andrew is in fact Angeline's elder son. Andrew is based in Indonesia, while Angeline is based in Singapore. I understand that together they provide a similar service under one roof to their clients on Indonesian franchising and licensing matters out of their Singapore and Jakarta law offices. So we have the introductions of our speakers. We are all here today because we are enthusiastic about franchising. Franchising and licensing are a great way to exploit and disseminate IP in a society. They are a wonderful way to match assets to resources. Intangible assets are the main trick in stock in trade for a franchise. For some of us who are relatively new to licensing of IP, would you allow me to give a short introduction? In a nutshell, licensing is a mechanism that allows your IP to be commercialized by using the resources of the licensee, and without the licensor having to transfer ownership of the IP away. Franchising is similar. It makes heavy use of licensing, in fact, particularly bundled licensing, so that it is licensing of entire business system, which will include brands, trade dresses, know-how, proprietary technologies, and other important pieces of confidential information. Franchising, wonderful as it is, also comes with many legal issues. For example, a franchisor may have to grapple with how to adequately protect its IP. If it fails to do so, the franchise may quickly lose its attraction, as the IP may be freely copied by others. And on this note, let us get the conversations with our speakers going. First off, we want to talk about IP protection. To ensure good protection of branding and proprietary technologies in particular, and these are IPs that are being used in a franchise. Andy, may I invite you to share with us some important things that one should look out for?
Thanks, Chong Yuan, and thanks very much for your kind introduction. As you rightly pointed out, IP rights are frequently vital to a franchise business. There are, broadly speaking, two classes of IP rights: registrable and non-registrable IP rights. If you reflect carefully, the IP rights are usually what attracts the franchisee to seek the franchise rights in the first place, such as the branding, which is registrable, and business know-how, which is non-registrable. In the interest of time, I will just share 4 points to look out for in protecting these IP rights. The first point is identify and protect. The franchisor must take great care in identifying these assets in its business and adopt the measures to protecting these assets before they enter the market country that they wish to exploit. For non-registrable IP, such as trade secrets or confidential information, which include details of the company's financial affairs, your recipes, formulas, and copyrighted materials, which may include instruction manuals, computer software, and databases, the franchisors should seek advice from their lawyers and take the necessary measures to properly safeguard such IP. Take, for instance, confidential information. The owners must first clearly identify or mark precisely what they say are confidential. Then they need to make sure the franchisee receives the confidential information under circumstances which creates an obligation of confidence. Now, that's quite a mouthful, but that is a very important test if you wish to establish breach of confidence. And this second element can be done by way of a contractual obligation under the franchise agreement. But more importantly, the owner's lawyers can help develop very clear policy statements in the franchise operations manual. In addition, the franchisor can conduct regular trainings with franchisees and their employees on these policies and how to treat information confidential, and require franchisees to monitor incoming and outgoing downloads and file transfers by their employees using endpoint monitoring tools so that records of such trainings are kept. And it is the development of such frameworks which will help the IP owners to prove that the confidential information was imparted under circumstances creating an obligation of confidence. Then you have the registrable IP, such as trademarks, patents, and designs. And for such registrable IPs, it's more straightforward. Budget permitting, franchisors should ensure registration of these rights And given that these registrable IP rights are offered protection only in the selected countries where you file for registration, this can be quite expensive. So this is a good segue to my second point, which is plan and invest. As I mentioned, registration of some of the IP rights like patents can be quite expensive. More so if you intend to seek protection in many countries. So franchisors should map in advance if possible. They need to envision what their short, medium, and long-term growth plans are. Calibrate that against their available annual legal budget. They can then work out with their legal advisors the level of acceptable risk and balance that against their available budget for protection. This way, the scope of protection increases gradually over time and in line with the budget available. Many years ago, there was a case of an express barbershop that had a very novel invention for vacuuming hair after a haircut. The product allowed for vacuuming to be done safely and in a hygienic way. This way, it could dispense with a wash, blow, and dry after the haircut. The franchisor had applied for this product patent in Japan for this hair vacuuming equipment, but not in Singapore. And without a patent protection in Singapore, the franchisor could not invoke patent protection to stop a former franchisee from starting a competing business and adopting a similar equipment. Now, this is a very common story. We do see franchisors from time to time adopting a very reactive approach. They only begin to consider the registration of their IP rights in a particular country where a prospective franchisee from that country approaches them for a franchise opportunity. By then, it can be too late. The third point is review and update. So frequently, the franchisor starts off with its original portfolio of IP rights. But these rights may evolve. Along the way, new IP rights are created. So take, for instance, a franchise in the F&B space selling pancakes. The franchise agreement provides the franchisor with trade secret protection of the different recipes of the pancakes on its menu. These different pancakes have different brand names applied to them. But over time, the menu is extended. The franchisee experiments with new recipes to accommodate local tastes. New brand names are created. New products are also introduced where the specification of goods under the franchisor's earlier trademark registration failed to cover. So question, who owns these new IP rights? Even assuming that the franchise agreement provides that any modifications or improvement to the IP will be required to be transferred to the franchisor once developed, it is still the franchisor's responsibility to take steps to protect them and update its own portfolio of IP. So it is important for the franchisor to review its portfolio annually to see whether there has been new IP rights created. And if so, it should take steps to have them registered or properly protected. And where necessary, the franchise agreements may have to be varied to take into account these supplemental rights. Yeah, back to you, Chong Yuan.
Thank you, Andy, for sharing your thoughts and also highlighting for us the importance of IP in a franchise and also how to protect IP, both existing IP and ongoing IP, right? Not to forget. Yeah. So the importance of IP to a franchise really cannot be understated. Now, IP rights are territorial in nature, as what Andy has shared, and subject to the law of the land. Although IP systems are converged to a degree, it can be a costly error to assume IP rules are the same everywhere. So, Andrew, you are based in Indonesia. Perhaps you'd like to share with us some insights into protecting IPs that are commonly used in a franchise, particularly in Indonesia. And Angeline, please feel free also to weigh in as you see fit.
Hey, thanks, Pak Chong Yuan. Assalamualaikum warahmatullahi wabarakatuh, everyone. So basically, in a sense, Indonesia has very specific IP laws. In a sense, what works in Singapore does not necessarily work well in Indonesia. So the important thing about Indonesia is that the franchisor must be aware that Indonesia adopts a first-to-file approach. So therefore, it's very important that even if you have plans to expand to Indonesia in the near future, you should just register the IP anyway, the trademark in most cases, yeah? So basically, in a sense, many times foreign franchisors, particularly those in Singapore, will receive information that no, you need to have an Indonesian entity to register this IP, which is not entirely accurate. So foreign franchisors are able to use their foreign entities to register certain IPs, in particular, the trademark with the Indonesian Trademark Office in Singapore, using the Singapore entity in Singapore. Another way that they can also tap onto this registration will be through the filing of the trademark via the Madrid Protocol. So it is important to actually tap onto these various benefits here offered under the current framework to allow early protection, like what Andy mentioned. It's very important because in Indonesia there are specific cases in the past that some opportunists will actually register some of their IPs of foreign parties, and then once the foreigner or the foreign brand enters Indonesia, then this will be subject to a commercial exchange. So in that sense, early protection is important, and it's possible to do so using a foreign entity in Singapore or even anywhere else in the world for that matter. And perhaps even you can tap onto the Madrid Protocol as well to facilitate and accelerate the trademark protection in Indonesia. Just bear in mind that Indonesia, the trademark registration will take about 2 years to complete. I know it's somewhat different from what you have in Singapore. So please factor in this time frame when the foreign franchisor wants to enter the Indonesian market and have its IP fully protected. Now, 2 years may seem a long time, but in practical sense, you only actually need to have it filed to the trademark office, and then for them to issue the acknowledgement receipt. So that will take about 3 months, and hopefully after 3 months, you have that receipt. No news will be good news, and will be leading up to the 2 years of final protection. Angeline, maybe if you have anything to share as well on this. Thank you.
Yes, I just want to highlight the importance of having your trademark registered in Indonesia, regardless of whether you are doing the franchise arrangement or via a licensing structure, because later on Andrew will explain what's the difference between a franchise and a licensing arrangement in the Indonesian context. But both you will need to have really adequate IPR protection. Okay, I just want to share with you very quickly a case which we handled for one of the top F&B chains and a group in Singapore. They manage restaurant in Indonesia, okay, for an entity. And lo and behold, that restaurant went ahead and registered the Singapore trademark in Indonesia. So the reason why this happened is because of two things. Number one, the Singapore group has not registered anything in Indonesia, has not registered the very famous brand, okay, in Indonesia. Secondly is they had a restaurant management agreement, but unfortunately, there wasn't any IPR protective provisions in the restaurant management agreement. And that gave the other party opportunity to actually register the Singapore brand name with the Indonesian Trademark Office. And it actually took us, I think, 2 years to fight all the way, okay, from the court of first instance where we lost until all the way to Mahkamah Agung, which is the Supreme Court, where we won. Okay, so justice prevails and the case was decided in accordance with its merits. So this emphasized the importance that Singapore or other franchisors, they must register the trademark and other IPR rights in Indonesia as soon as possible. Yeah, thank you.
Thanks, Angeline and Andrew for sharing with us these wonderful insights. Well, I guess if the IP is a proper subject for a registration, it is definitely important to seek registration in Indonesia. But Andy earlier has mentioned some unregistered IP rights under common law. Right. In Indonesia, just wondering whether would there be such protection for unregistered IP?
Yes, thanks, Pak Chong Yuan. So in a sense, the protection will be actually under the principle of freedom of contract under the Indonesian Civil Code. So again, parties are free to put in place documentation where there will be a specific obligations in those agreements to ensure the sufficient protection of the various IP rights. Of course, like for example, patent, copyright, some of which can be registered, but those that are unregisterable, then of course we will need to rely on contractual undertakings. So it is very also important to also take note that in terms of enforcement, the governing law, the agreements, and how that would actually work in favor of the foreign franchisor and how the rights can be adequately protected from the Indonesian law perspective. Thank you.
Thank you, Andrew. Indeed, very helpful views on IP protection, and also, I guess, very pragmatic as well, right? So I think on that note, it will be great for us to move into a slightly different area to discuss regulatory concerns. So while some countries, such as Singapore, have taken a laissez-faire approach over franchising activities, other countries, such as Indonesia and Australia, have preferred a regulatory approach. So Andrew, tap on you again. Would you like to share a bit more with us, with our participants who may be getting into a franchising relationship in Indonesia, some insights into the regulatory compliance in Indonesia?
Right, thanks, Pak Chong Yuan. So basically, there are three main phases for the foreign franchisor to address this. So of course, the first phase would be the franchisor will itself need to be qualified to be deemed as a franchisor under the Indonesian franchise regulations. That's one. The second one would be, of course, before even entering into the franchise arrangement, there are certain Indonesian law-specific documentation that needs to be put in place. For example, you need to have the prospectus as well as the franchise agreement. And take note that Indonesian law even prescribes, the format, the contents, and even the timing of when the franchise agreement can be signed. And even the fact that you need to have a sworn translator to translate the agreement into Bahasa Indonesia. So this will be the second phase. And the third one will be, of course, once the franchise agreement has been signed, there will be ongoing compliance, even though as a foreign franchisor. But the compliance, of course, will be very minor. In this case, will be actually to have the franchisor STPW, Surat Tanda Pendaftaran Waralaba, or in English would be the franchisor certificate. They will need to obtain this certificate. So these are the three main steps which the foreign franchisor will need to contemplate and comply with in order for it to become a franchisor under Indonesian laws. Now, but in the event if the foreign franchisor, for example, is unable to meet these requirements because, for example, they don't have 5 years of experience as a franchisor in other jurisdictions outside Indonesia, then of course there's another alternative, which is the licensing approach. And the licensing approach will be a lot less regulated in the sense that you only need to have a licensing agreement. And this licensing agreement, as part of overall compliance, will need to be registered with the Ministry of Law and Human Rights after signing. So whether for franchise or even for licensing, the IP registration is something which the authorities will ask for. So in a sense, comes back to the first point, the IP registration is very important in terms of regulatory compliance when it comes to franchise under Indonesian law. Thank you, Pak.
Thank you, Andrew. And thanks especially for sharing with us, so many formalities involved when it comes to regulatory compliance in Indonesia. So I think underscore the importance of seeking proper legal advice. Yeah, and also, but I mean, other than formalities, just wondering whether there are also substantive issues to look into for regulatory compliance. And maybe I can invite Angeline to share a bit in this regard, and also any practical matters, from your experience that will be helpful for our participants.
Yes, thank you, Chong Yuan. Right, I've got actually 3 topics. Yeah. Okay, the first is that typically a franchisee is a limited liability company, right? So it will be advisable to actually have their shareholders, directors or commissioners to actually sign guarantee or at least a form of a surat pernyataan or a letter of undertaking, right? Actually to guarantee or to procure the franchisee to comply with their obligations under the franchise agreement or procure the licensee to comply with the obligations under the license agreement. Now, because these directors, shareholders, commissioners, they are many individuals, right? So under Indonesian communal law, it's very important to get so-called spousal consent, yeah, if they are married. Right, so what is this? Because under Indonesian communal law, a husband has a 50% interest in the assets of the wife and vice versa. So in my experience, a lot of my clients will ask me, Ibu Angeline, which spouse to ask? Okay, just a joke. Okay, so the second point is that when it comes to remittance of funds, then of course we have to consider the tax aspect of it, basically the withholding tax. So if you want to receive $100 net, right, so you need to gross up to 111, and then after deducting the 10% tax, withholding tax, then you receive the $100 net, for example. So it's very important to have the relevant provisions in the agreement. And last but not least, I would like to highlight that Indonesia, there's a lot of hearsay information, right? You hear from a party A and someone else tell you it's actually B. No, it's not A, right? And no need to get spousal consent. So, and then yet another party will tell you C, right? So it's very important to actually get independent legal advice and then for you to actually verify. And very often the so-called market practice, everybody is doing it, okay, may not necessarily be the correct legal position. So these are the points I like to highlight. Thank you.
Thank you very much, Angeline, for sharing with us. Very interesting points. Yeah, and I guess it's part of the legal advice. The information that has to come, that has to come from the franchisor, in order for the franchisee to decide on certain matters, will be important. Yeah. So, and I know that regulatory compliance covers information disclosure as well. But information disclosure is not there just for regulatory compliance, but also for the parties to conduct their own due diligence. Yeah. And a due diligence exercise is really one that should be done before the parties contract themselves into a franchising relationship. So, Andy, you have taken a break for a while now, so can I put you in? Perhaps I can invite you to share some important areas of due diligence review from both the angle of the franchisors and the franchisees. And furthermore, if there are any areas that are more for specific industries, experience, we also love to hear them. So, Andy, over to you. Thank you.
Sure, Chong Yuan, thanks. As you rightly suggested, unlike some countries, there's no statutory requirement in Singapore for a franchisor to file what is known as a franchise disclosure document annually and provide it to every potential franchise buyer before the franchise sale can be completed. But it is good practice for both franchisor and franchisee to conduct due diligence reviews on their counterparties before they enter into any franchise relationship. And entering into a franchise relationship is a complex investment. So the due diligence review can really help parties with information that they can use in making a decision whether to contract and to avoid allegations of misleading claims. As this is quite a substantive area, I will just highlight a few areas applicable to either the franchisor or franchisee in the interest of time. First is the identification of the parties, any parent entity, affiliate, or as Angeline had mentioned, directors and the controlling mind. So it's important to look for, how long the party has been in business, who the individuals are, as well as whether the party has started other businesses. Such information can provide a more complete understanding of the company's business experience, future growth and success, and a glimpse of any prospective competition. Second, litigation. Litigation searches will view information on prior civil and criminal involvement or litigation. So whether the parties or any of their executive officers and directors have been engaged in franchise litigation or convicted of offenses relating to, for instance, fraud or unfair practices. I think, it will certainly color your judgment as to whether to enter into a contract with such folks or not. Third, bankruptcy, insolvency searches. I think this is quite self-explanatory, very important. Fourth, IP rights, in particular registrable IP rights, such as trademarks, patents, registered designs. And just like the anecdote that Angeline mentioned, we experienced a similar situation in China where a proprietor trademark search on a prospective and franchisee disclosed a pending trademark application in China, which was similar to the franchisor's registered trademark in Singapore. So it is very important that potential franchisees check as the IP clauses in the franchise agreement carefully and are thoroughly aware of and understand their obligations with respect to the use of the franchisor's IP. And a prospective franchisee would also want to know the nature and the scope of the licensing rights to be held, whether these are granted equally to the franchisee and whether they are capable of being modified during the term. Fifth will be audited financial statements. This will yield information on the financial health of the party in question, whether franchisor or franchisee. And then finally, restrictions on sources of products and services. So this is highly dependent on the type of the franchising industry sectors, as you hinted just now, Chong Yuan, where the review is being targeted. So it's important to note that this part of the review can involve finding out what local authority consents may be required before the business can be operated legally. For example, franchises that are in the food and beverage industry generally will require food licenses and or liquor licenses, and franchises in the cosmetic and healthcare industry are subject to product registration regimes. Yeah, I'll turn it back to you, Chong Yuan.
Thank you, Andy, for sharing. Although the focus of our webinar is on intangible assets, but when it comes to due diligence, Andy, as you have pointed out, many of the issues involved are not traditionally, I'm not really speaking about intellectual properties. And having the experience, I think will really be very helpful. So maybe let me quickly circle back to Andrew and Angeline. Would you have any further insights and experience on franchising due diligence that you'll be happy to share with us?
Yes, thanks, Pak Chong Yuan. So basically, in a sense, due diligence for when it comes to franchising arrangement in Indonesia is also very important because sometimes, from our experience, from our observations, finding the good partner is not enough. You must find the right partner. Yeah, the right partner must see the same thing, do the same thing, so both parties get the same thing. So that is very, very crucial, and it's important to have the same vision when determining the right partner, so that to make sure that your brand really becomes a success in Indonesia, because Indonesia has a very, very, very big economy. And so therefore, finding the right partner will be able to position, the franchisor's business expansion into Indonesia towards greater success. Angeline, maybe you have something to add as well?
I think basically, in view of time constraints, I think basically I'm okay with it. Yeah, thank you. Thanks, Chong Yuan.
Yeah, thank you, Angeline and Andrew. Yeah. So I'm sure some of us are taking down notes. So very helpful points indeed. But as the saying goes, all good things must come to an end. And both franchisor and franchisee will want to end well. And that may mean we have to plan ahead for a good ending. Andrew, may I first invite you to share, what legal tools and mechanisms are available for maximizing the chances of an acceptable, if not a good end game for both parties in an Indonesian franchise?
Right. So in a sense, with regards to the termination or exit strategy, it all comes down to the documentation. So the parties will need to first put in place a very clear exit mechanism protocol in the event either party wants to trigger that clause. So that's something which franchisors should really look and perhaps even invest into, so to make sure that when it comes to exit, it will be smooth and uncomplicated, because in the Indonesian context, it is always advisable to reach an amicable settlement. Of course, even though previously under the franchise regulations, there needs to be a clean break, but now under the law, it's no longer applicable. So that is, in a sense, it's more liberated and parties are free to decide. But then again, if amicable settlement is not possible, then of course, the Indonesian law will always prescribe two natural formats: is litigation at the district courts or arbitration. Now, arbitration, you can do it in Indonesia through BANI, or you can choose a foreign venue such as SIAC. So when it comes to litigation, I understand that most foreign franchisors are more comfortable with arbitration process instead rather than litigation. So for litigation, you can always consider SIAC in Singapore. Although do note that the SIAC award will need to be applied to be enforced via the Central Jakarta District Court. So enforcement is not automatic. We need to apply for it. And do note that during application stage, it is also important to cover the application stage and follow up well, because application stage is not automatic again, and the courts actually do have a residual power to choose not to enforce the SIAC. So just need to make sure that the franchisor has got all angles covered to make sure that enforcement is smooth as well. Angeline?
Yes, I just want to add. A couple of points, more from the practical and logistics perspective, right? So if you want to have an exit scenario, it's very important to make sure that to minimize disruption to the business, to the franchise business. Because can you imagine, right? If you terminate the franchise agreement, then you will need to have someone to actually take over the operations, right? Then you have to maybe line up employees, line up a landlord. The worst thing that can happen is that, overnight, all your 100 outlets close shop, right? So in other words, you need to map out almost like a quasi-military operation, to take control of the operations, and then talk to the employees, line up the key personnel, and also importantly is to talk to the landlord. Now for franchise agreement, which has a clause to novate the lease agreement, that's no issue. But if not, then you really have to approach the landlords and engage them, and then have a contingency plan, A, B, C, D, E. So I just want to highlight that we have to take note of the practical aspects also. Yeah, thank you, Chong Yuan.
Yeah, absolutely. Thanks, Angeline, for bringing out this practical aspect when it comes to potential disputes. Well, I guess despite the most thorough contract drafting, there could always exist some scenario of dispute that were not initially envisaged, and when dispute happened, relationships got soured. So maybe let me circle back to Andy, and you have a lot of practical experience on this front as well. Any stories and suggestions that you would like to share with us?
Thanks, Chong Yuan. I think there are a few important points that franchisors should take note of. As Andrew had touched upon this, the first will be the dispute resolution clause. I think Andrew mentioned on the termination clause. The dispute resolution clause is what we call the Cinderella clause. And the reason is because it's frequently left to the 11th hour, where all the seemingly more important provisions of the franchise agreements have been ironed out and agreed to. And parties in their haste fail to carefully consider what happens in the event of a dispute. So you need to ask yourself, what is the dispute resolution mechanism that you want to adopt? And be mindful that one size doesn't fit all. It has to fit the jurisdiction, whether it is litigation, arbitration, mediation, or even a combination, what we call the met up clause. So mediation first, and if mediation fails, arbitration. And with the Singapore Mediation Convention, it is quite an important tool to consider. For jurisdictions like Indonesia, I completely agree with Andrew that you should try mediation. After all, it's very much aligned with the Southeast Asian culture. You need to ask yourself, is the court in that country where you seek to resolve a dispute against the franchisee judicially transparent and fair? You need to think about the cost ramification, because if you go by way of arbitration, the cost is frequently a lot more than litigation. Which governing law would be favorable to you? That's again something to consider. And if it's arbitration, should it be a single arbitrator? Should it be a panel of 3? It's important to allocate careful thought on this provision. For franchisor, you can really lose the crown jewels, your IP rights in that jurisdiction if you don't pay attention to this. The second is the paper trail. I think it's very important for parties to understand that whether you succeed in litigation or arbitration, it will ultimately turn on the quality of your documentary evidence. Well before any termination, if you sense that the termination is going to be contentious, get your legal advisor in as early as possible to plan your exit strategy. A good counsel will lay the paper trail fairly early on and build up the case for you for termination. This is super important because a wrongful termination will open you up for claim for breach, or it could be in response and they will file a counterclaim against you. The third will be audit provisions. Audit rights in your franchise agreements provide the franchisors with a very good indicator of a franchisee's financial state of affairs. Typically, the audit provisions in a franchise agreement will allow the franchisors to conduct audits of sales and revenue numbers at the franchisee outlet on an annual or biannual basis. However, wider reaching audit provisions can help grant the franchisors to monitor the financial health of franchisees and to detect any irregularities. The franchisors may consider including a clause empowering them to carry out outlet inspections if there are reasonable grounds to suspect the franchisee is under some financial distress, or if the franchisee has defaulted on payment obligations, or develop an effective audit program to ensure that any wide-ranging rights introduced are not emptied of their substance. So franchisors should ensure that the audit programs are tailored to allow the access into the company's financial reporting. I pause there and turn it back to you, Chong Yuan.
Thank you, Andy. And also thanks to Andrew and Angeline for preparing our audience for a good franchising ending. All very good points, and I hope you, our audience, you are enjoying it as much as I have. It's about time for us to close this webinar. So let me just say that let's keep in touch, right? And my best wishes to you, our audience, on your franchising journey. May I hand over the time now back to the host?
Thank you, Chong Yuan and your fellow panelists.